All right. All right, let's go ahead and get started. I'm going to call, and I do not have a gavel, so we'll get creative, but in my cube here. But we are going to call this meeting of the Common Interest Community and HOA Work Group to order for today, which is the 15th of November, 2024. And with that, we do actually have at the top some orders of business around meeting minutes. And I think we may actually have, and I will refer to staff, I think we may have 2 sets of meeting minutes that need to be approved. Is that correct?
Yeah, Madam Chair, the last minutes for the our previous meeting and this meeting need to be approved. So you can do that as one vote if you'd like, if members have had a chance to review those. Yeah.
Okay. And can you remind me the dates of those meetings quickly?
Yes, Madam Chair, that'll be the October 25 meeting.
Yep.
And the October 4 meeting. So the minutes for both those meetings.
Okay. Having looked at the meetings, do we have someone who would like to make a motion to approve the meetings for October 4th, 2024 and October 25th, 2024?
So move, Madam Chair.
Thank you, Vice Chair Lucero. That being said, all in favor of approval of the minutes, please say aye.
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 Aye. Sorry, everybody's on mute.
Aye.
Any nays? Hearing none, we're going to consider those meeting minutes approved for October 4th and October 25th. Thank you all for that. And then we will move on to the next point of our agenda. And I will briefly just go through a few housekeeping things. I want to welcome everyone, of course, into the work group once again. For folks who have not been on the work group before, I just want to remind us that the purpose of this work group is to study the prevalence and the impact of CICs, or common interest communities, and homeowners associations in Minnesota, and how existing laws regulating these entities help homeowners and tenants access safe and affordable housing. And specifically today, we are going to speak on the topic of governance in the statute, and talk about sort of the governing documents commonly used by these entities, as well as common practices or best practices, anything that creates barriers for participation by homeowners in the board of directors or CICs. A few quick notes on decorum. I just want to remind everyone here that, as we know, I completely understand that this is an incredibly passionate topic, and for many, a long-standing issue. So I just want to remind folks that we always want to treat each other with respect and keep a polite level of decorum amongst members, testifiers, and speakers. I want to also remind us that all comments should be directed through the chair, which I know is a little bit unusual for folks who are not accustomed to it. Please do not directly ask the presenters. Please ask to be recognized by the chair, and I will help regulate the discussion for you. And we also want to remind folks to call either by their title, Member Smith, Member Jones, for example, or Chair, Vice Chair, and so forth. And for testifiers to please call them by whatever is their preferred mode of address. As far as time limits, I do want to be clear that if the agenda requires, we'll ask that you wrap up final comments so that we can keep the meeting moving and keep it on time. I also would like to tell folks that for future public testimony, we are looking at the possibility of some listening sessions to be held in sort of the four corners of the metro area to bring folks in to be able to testify from the public, just to listen and hear all of those stories and expertise to help inform our decisions as we think about making recommendations based on this work. Lastly, I will tell you that we, you know what, I'm going to skip that part for right now. We'll go back to it later and just move ahead in the agenda. We do have a couple quick announcements for today. We do have a brand new member joining us today, Representative Meckland. Representative Meckland, do we have you on the call today? There you are.
I am here, Chair.
Good morning. So if you wouldn't mind, I will give you the floor for a moment, Representative Meckland, just to introduce yourself and tell us about how you came to be interested in working with the work group here today.
Well, thank you, Madam Chair. When I became aware that this group existed a few weeks back, and found out that there was not a member from the Republican caucus, House, I did ask to be placed on this if nobody else was in line to do so. And in part, my background is I am a general contractor, so I build for a living. And there are lots of pros and cons that we encounter when it comes to HOAs and CICs. So I found it to be a very fascinating topic, and that's why I chose to be here. Will be starting my 7th year, I believe, next January. So let's proceed, if we may, Madam Chair.
Fantastic. Thank you, Representative Mecklen. And I think that is a great perspective to have in terms of membership of the council. Just to be clear, we did ask for a member. I don't know if they just didn't have one available or somebody who was interested. So we are delighted to both have you and to have someone who is interested in the topic and can make some really great contributions to the discussion. So thank you and welcome, Representative Mecklen. We're glad to have you. All right, with that, I am going to turn it over to staff to go ahead and give us the quick rundown of the agenda for today. Abra?
Thanks, Madam Chair. Can you see my shared screen with the agenda on it?
Yes.
Okay, wonderful. I just wanted to go over our agenda. We're on agenda item 3 right now. We've already completed adoption of the previous meeting minutes and the welcome and purpose. In a moment, we'll switch over to a presentation by Ms. Mary Davis from House Research staff with an overview of the current state statute, followed by presentation number 2, which is the national perspective from Ms. Heather Norton from the National Conference of State Legislatures. Then there will be an opportunity for questions and answers from work group members and discussion. Unfortunately, our community's perspectives testifier wasn't able to be here this morning, so we're going to skip that component and we'll use the rest of our time around the current existing statute, as well as discussion on emerging recommendations, followed by next steps and adjourn. And just a note at the bottom that in addition to the public listening sessions, for future meetings, there will be opportunities for public input. And if you're interested in testifying, you can email andrew.george@lcc.mn.gov no later than 3 days before the scheduled meeting. All right, I'm going to stop sharing my screen and turn it back to Madam Chair.
Thank you, Ms. Pollock. And just a reminder, we do have rotating meetings with every other meeting being having an in-person component if folks feel more comfortable there, and the other being entirely remote, but there's always a remote option for participation. We want to make sure that folks across the state feel comfortable coming to speak and share their experiences and their testimony. So I just want to make sure that that is clear as well. All right, then we will move on to the next piece of our agenda and the presentations. And the first presentation we have today, we have Ms. Davis from House Research here to give us sort of an overview of the state perspective. And we will go ahead and go with that. Once we get through both of the presentations, we'll hear from both Ms. Davis and Ms. Morton first, and then we will have a session for some Q&A to ask questions of our presenters before we move on to the next portion of the agenda. And with that, I am going to turn it over to Ms. Davis in House Research.
Thank you, Chair and members. Hopefully you can hear me okay. Chair and
Just
members,
fine.
Oh, great, great. Chair and members, my name is Mary Davis. I'm an analyst with the House Research Department, and I work on housing policy and real estate issues, and specifically things related to common interest communities and HOAs. And we can go to the next slide. So today I was asked to present on issues related to common interest communities and specifically the governing documents and the Minnesota laws that apply to those governing documents. I'm going to do a pretty high level overview. We only have 10 minutes, but hopefully that will spur some questions and other things that you want to think about going forward. I'll start by explaining the application of chapters 515, 515A, and 515B. These are the Minnesota laws that govern CICs. Then we're going to talk about what governing documents are and which statutes apply. And finally, we're going to consider who administers those governing documents and how they do that. Next slide, please. So the reason we need to look at the application of statutes for Minnesota law is that there are 3 chapters that sort of show the history of CIC law in Minnesota. Chapter 515 is the Minnesota Condominium Act, and it governs condominiums that were created prior to August 1 of 1980. Chapter 515A is the Uniform Condominium Act, which applies to condos created on or after August 1 of 1980, but prior to June 1 of 1994. And finally, Chapter 515B, the one we predominantly use now, the Minnesota Common Interest Ownership Act, which applies to CICs and HOAs created on or after June 1st of 1994, and then with a fairly complicated application section, also applies to many of the actions and events for those CICs created previously. So now you have kind of an overview of which chapters of law we're going to be looking at, and we can go to the next slide. So now we'll talk a little bit about governing documents. We'll start with the declaration. This is the document that creates the CIC. It controls the CIC association along with other documents and laws. It often starts with a developer who then controls that CIC and association for a period of time. And if you look at Article 2 of Chapter 515B, that's our main governing chapter now, 515B, you can see that there are laws that explain how to create the CIC with the declaration, how you amend a declaration, and then how you can merge or terminate or add additions to a CIC. And those are all contained in that article of Chapter 515B. So next is the Articles of Incorporation. Most CIC associations are incorporated as nonprofit corporations under Minnesota Chapter 517A. This law provides what has to be in the Articles of Incorporation for a nonprofit. And there's a specific statute that lists those, and that's 517A.111. CICs can also be organized as for-profit corporations, and they can also be organized as cooperatives. So these provisions control how the association operates along with the other governing documents, which such as the bylaws, which is what we're going to talk about next. So if we want to go to the next slide. So bylaws are what many associations have in addition to those articles of incorporation. You often hear about the bylaws. It's how they run their meetings a lot of times. And they're used to provide direction for the actions of the association. There is a statute in Minnesota law at 317A.181 that discusses, the creation and use of the bylaws for a nonprofit. And then finally, there's rules and regulations that the association has, and also an association budget. These aren't true governing documents, but they are documents that control and bind the association and their members. They're passed by the association using articles and bylaws, and they're binding on the spending and activities of a CIC or an HOA and their members and their member units. Next slide. So who administers the governing documents? I think if we were all in the same room together, you all would have shouted the association, possibly, we'll hope. So there's a Minnesota statute that discusses the powers of the association and what this chapter requires. It has to be made up of unit owners. And then the association can create, amend, and revoke rules regulating the CIC, including rules related to member conduct, visitor conduct, damages, animals, and the appearance or the exterior of the CIC. The association is allowed to adopt a budget and also levy and collect assessments. They're allowed to hire managing agents and independent contractors. The association can litigate and sign contracts on behalf of the CIC. They can maintain, repair, improve, and regulate the use of the common elements of the CIC. And they can provide for, they are required to provide for the indemnification of officers and directors and maintain directors and officers' liability insurance. And they're also required to follow reasonable procedures for meetings and the election of directors. So that's pretty comprehensive. This is all in Article 3 of 515B. Next slide. So now we're going to talk about how they administer those governing documents. And again, this is Article 3 of Chapter 515B. So this article contains many of the provisions regulating CIC associations and providing their powers, their activities, and their duties. So if you're looking for laws related to the board of directors, the officers, and their open meeting requirements, that's in 515B.3103. If you're looking for statutory requirements for the bylaws and the annual meeting requirements for the association, they're required to have an annual meeting. Those are in 515B.3104. If you're looking for the law on the upkeep of CICs and the preventative maintenance plans that are required, that can be found in 515B.3107. Meetings and the notice for meetings, there's a requirement notice of meetings. Those are in 515B.3108. If you're looking for quorum and voting requirements, those are in sections 109 and 110. And finally, this article talks about the provisions related to the liability of the association and taking on liability for the CIC, lawsuits, insurance requirements, reserve funds, assessments, liens, records, and accounting, and accountability for those. And that's all in sections 111 to 121 of this article in chapter 515B. We can go to the next slide, which is questions. So the idea here was to give you guys kind of a big overview of what's contained in this chapter of law, particularly 515B, and to kind of give you some ideas about what the law has in it right now and where you might want to look in the future. And that's everything for today.
Okay. And with that, we are going to have Q&A available, and Ms. Davis will stand by, but we're going to go ahead and go to our second presenter first, and then we will open it up to discussion by the members. So with that, do we have Ms. Morton handy? And there she is. I will be very upfront. I work a great deal with Ms. Morton, typically when we talk about things like artificial intelligence and cybersecurity and data privacy, but she is multi-talented and also works with the NCSL on issues around the topic we have before us today. So with that, I'm going to introduce Ms. Morton, let her kind of give you a quick overview of her and her work, and then go into her presentation. Ms. Morton, you have the floor.
Thank you so much. Let me pull up my slides here and make sure I can actually see the... Okay, and can you see the slides and you can hear me okay?
Yes, you are coming
Perfect.
through crystal clear. And I should have mentioned, I suppose, that if it wasn't already obvious, we had Miss Davis gives us sort of a state perspective, and Ms. Morton will give us sort of a little bit more of a national perspective on what we're seeing across other states. All right, go ahead and proceed.
All right, thank you so much. Good morning, and thank you, Madam Chair and members of the work group for the opportunity to speak to you today. For the record, my name is Heather Morton, and I cover financial services issues for the National Conference of State Legislatures. And I'm pleased to provide you with an overview of some of the governance requirements for common ownership associations. And for those of you who aren't familiar with us, NCSL is the country's most trusted bipartisan organization that serves legislators and staff for 50 years. We serve all 50 states, territories, and commonwealths. NCSL is headquartered in Denver, Colorado, where we provide comprehensive and unbiased research on state policies and legislative institutions. We also have a small office in Washington, D.C., and their work focuses on ensuring state legislatures have a strong, cohesive voice in the federal system. NCSL does not make policy recommendations to the states, nor do we advocate certain positions to states. Instead, we promote policy innovation and we facilitate communication amongst the states. We do this because we believe in the importance of the legislative institution and know when states are strong, our nation is strong. So to start off, I'm going to do a quick level set and refresh because I know you've heard some of this information before, but I just want to make sure everybody's on the same page. And then I'm going to quickly highlight some of the governance provisions that states have been enacting regarding what I call common interest communities or common ownership associations. And so these are also known as, they can include homeowners associations, condominiums, cooperative associations, planned communities, and some condominium hotels. These associations and communities, they aim to set and maintain standards that may boost property values, preserve community aesthetics, and may maintain some common development elements, like swimming pools or clubhouses. They take care of landscaping, trash removal, and other amenities. However, common ownership associations may also seem restrictive to some homeowners because they do set and enforce architectural guidelines, maintenance standards, and noise restrictions, among other things. And states like Hawaii and Utah started enacting condominium legislation back in the early 1960s, and then legislation that regulated planned community developments and homeowners associations followed after that. And as you can see on this page, with this map, every state, Guam, Puerto Rico, the Northern Mariana Islands, the U.S. Virgin Islands, and Washington, D.C. have all enacted some kind of condominium or horizontal property community association law. And 16 of these jurisdictions, which are in gold, and so that's Alabama, Alaska, Arizona, Kentucky, Louisiana, Maine, Minnesota, Nebraska, New Mexico, Pennsylvania, Rhode Island, Texas, West Virginia, and the Northern Mariana Islands have enacted the Uniform Condominium Act that was from the Uniform Law Commissioners. And the remainder enacted what I refer to as like state-specific condominium laws. So they didn't necessarily, they may have used the ULC as inspiration, or they may have come up with stuff on their own. And in an effort, so in that effort to create some uniformity between the state laws, the Uniform Law Commissioners drafted and published the Uniform Condominium Act in 1977. And then they also published the first version of the Common Interest Ownership Act in 1982. And that Common Interest Ownership Act has been revised 3 additional times, with the most recent version released in 2021. And for background information, according to their website, ULC members, they must be lawyers that are qualified to practice law, and they are practicing lawyers, judges, legislators, legislative staff, and law professors who have been appointed by their state governments, as well as the District of Columbia, Puerto Rico, and the U.S. Virgin Islands. And they research, draft, and promote enactment of uniform state laws in the areas of state law where uniformity is desirable and practical. And the uniform law members, the Uniform Law Commission members are referred to as commissioners. They donate all of their time and legal and drafting expertise every year as a public service, and they receive no salary or compensation for their work. And then turning to homeowners associations and other planned communities, there we go. 10 states, Alaska, Colorado, Connecticut, Delaware, Kentucky, Minnesota, Nevada, Vermont, Washington, and West Virginia have enacted one or more versions of the ULC's Uniform Common Interest Ownership Act, while the remainder enacted more state-specific laws. So recognizing that we have limited time, I'm going to shift gears a little and I'm going to highlight some of the governance provisions. And just so you know, I'm going to move really quickly through these because there's a lot in these laws. But I wanted to give you a high level overview of what some of the common provisions. I will be sharing my slides with the LLCC staff so that you can refer back to these maps as the work group continues its work. So this next map highlights in red the jurisdictions that have specified that board members owe a duty of care to the association and to the unit owners. The duty of care can be described in the statutes from requiring reasonable care or good faith, all the way up to acting as a fiduciary. Then on this slide, 9 states have specific language that addresses potential conflicts of interest for board members. For example, Colorado defines in their statute that a conflict of interest is a contract, a transaction, or other financial relationship between the association and the director of an association, or it's between the association and a party that's related to a director, or it could be between the association and another entity in which the director of that homeowners association is also a director or an officer and has a financial interest. Then on this slide, the next slide, the states that are highlighted in brown have specific requirements that one or more of the association types shall incorporate as a corporate entity, much like Minnesota, like a for-profit or a nonprofit corporation, a cooperative, or even a limited liability company. And with this requirement to incorporate, that does mean that the association must comply with that entity requirement, that incorporation requirement under the state corporate regulatory code. So if an association is required to incorporate as a nonprofit corporation, they have to follow the nonprofit requirements in addition to the association requirements. Then on this next map, the states that are highlighted in gold on this slide are required to file some kind of registration or a certificate application with a state agency or office. And so, for example, Utah requires that an association has to register with their state Department of Commerce and no later than 90 days after the recording their declaration and creating their association and their community. With that registration, the association must provide the name and address of the unit owners, the contact information for the president of the association, and then also the contact person who communicates the payoff information for selling or refinancing a homeowner's unit. And then, of course, they have to also pay a registration fee. And if that association doesn't complete that registration requirement, then the association can't place a new assessment lien or enforce an existing assessment lien until that association comes into compliance. So they have to maintain that registration as well. And of course, there are a lot more governance requirements, but I'm going to stop the map madness for you with just this last map that highlights the states where I found a requirement to complete some kind of education, or where the state provides that board members can access educational materials to improve their knowledge and skills to serve on the association's board. So, for example, Florida does require that directors submit a certificate that they've completed an educational curriculum within 90 days of either their election or their appointment to the board. And this certificate is valid up to 4 years. And the curriculum that is specific to newly elected or appointed directors must include training that relates to financial literacy and transparency, record keeping, levying of fines, and notice and meeting requirements. And they put into statute that if the director doesn't file that educational certificate within 90 days, the director will be suspended from the board until they comply with that requirement. And it allows the board to temporarily fill the vacancy during that period of suspension for that board member. So, as I'm winding up my presentation, here are some suggestions for different ways that you can access NCSL's resources. I will say, unfortunately, I don't have a lot of the Common Ownership Association resources posted on our website, but you can always contact me and I can share that with you after the meeting or, down the road. And I would be remiss if I didn't make a quick shameless plug for the next NCSL Legislative Summit, which is our annual meeting. We'll be in Boston in case you're interested in attending. And so finally, thank you, Madam Chair, for the opportunity to provide all of you with this high-level overview of state laws regarding governance requirements for these common ownership associations. And as I said, I'm happy to answer any questions and provide additional information if needed. And I've provided my contact information on this final slide. Thank you so much. Excuse me, sorry.
Sorry, I need to come off mute. Thank you for that. Two really excellent presentations. And with that, I am going to open it up to members to ask questions of Ms. Davis and Ms. Morton. If you have any, do we have any to start us off? Because I can certainly jump in with a few if not.
Madam Chair, I do. I was looking for how to raise my hand.
Yep. It's a little bit challenging. Just as a quick reminder, I believe it is under the react button, if I'm not mistaken, is how you raise your hand. But go ahead, Ms. Cole, or Member Cole.
Thank you. I appreciate the presentations. One of the questions that I have is around has to do with the enforcement and the relationships. The association is established for the purpose of enforcing the CCR. So wouldn't that make the association an agent of the municipality who created the development? Another thing is why isn't the municipality responsible for the conduct if the association, the purpose of the association is to enforce the CCRs? The other thing I am looking to clarify is, yes, I do appreciate that the fact that they are established as a nonprofit, but in Minnesota, a nonprofit can be anything. Minnesota doesn't clarify what a nonprofit, there's no real qualifications. Minnesota says that nonprofit, anybody can incorporate anything as a nonprofit for any legal reason, but it is only the public charities that are actually regulated. So anyway, my question is, what about the relationship to the municipality, and why isn't the municipality responsible for the association when the association's purpose is to enforce their rules and regulations?
Okay, that was a few questions to unpack in that particular vein. And I don't know if Ms. Davis or Ms. Morton has thoughts on those specific questions. And one point before we move on, Member Cole, can you just clarify for the general public, anytime we use acronyms, I like to have folks at the very least disclose what that acronym is one time so that folks are all on the same page. If you could just recognize what a CCR is and what that stands for before we move into the questions.
CCR is the covenants, contracts, and restrictions. That is the contract between the municipality and the builder that comes into play to establish the development that eventually becomes the homeowners association. So if it wasn't for the CCRs, the HOA wouldn't exist to begin with.
All right, thank you for that clarification. And then Ms. Davis, Ms. Morton, any thoughts on those particular questions?
Sure, Chair and members, I don't know if I have a clear answer on the first question, but generally speaking, under Minnesota law, the association and the builder are not perceived to be agents of the municipality. So I think that's the short answer. But I think you could frame it that way conceptually if that's useful, but that's not really how it's viewed under current law, as far as I know. The establishment of a nonprofit, that's correct, that the nonprofit under Minnesota state law is that it does not have to be charitable. That's a requirement of the federal tax code. So anyone can create a nonprofit in Minnesota, and there are laws under Chapter 517A that govern those nonprofits.
And just for clarification, Ms. Davis, so you said that they do not, a nonprofit does not need to be a charitable entity, and that is federal law that we're complying with on that level, not state?
In terms of being like a tax exempt entity, that's federal law. And in, you know, a nonprofit has to comply with everything in the nonprofit chapter. But if you're talking about like a charitable tax exempt organization, that's a federal designation, and you don't have to be a federal tax exempt organization in order to be a nonprofit in Minnesota. But you still have to comply with the requirements of being a nonprofit in Minnesota, so a not-for-profit company.
Thank you. And on that point, do we know, Ms. Morton, if other states, just out of curiosity, and maybe you know the answer, maybe you don't, do require nonprofits to have that federal tax designation, or do they have a much broader definition of nonprofit?
Thank you, Madam Chair. And Member Cole, to your question. So there are different types of nonprofits, and as Ms. Davis was referencing, that one type under the Internal Revenue Code is the 501c3, and it gets to their tax status. And so, but that's under federal law, but for the most part, the states, you know, they may have different types of nonprofits as well, or that they're for profits. They can be, sometimes they might be that they are actual corporations. They may also be limited liability companies, or they could be unincorporated associations. So there are various different avenues under the state laws. And some of the there are different benefits to being either a corporation or a limited liability company, because it does, in addition to some of the tax benefits, right, it also can help protect the assets of excuse me, I'm sorry, I can't get rid of this tickle in my throat. In terms of, you know, like, so if there is, you know, if there is a court case or something, a lawsuit against the association, in their corporate formation, it does give them, protections for the liability of the individual directors, so that it's not perceived, as being, you know, so that their personal assets are not, if they maintain that corporate entity and those requirements, then it will protect their personal assets from maybe being claimed as potential damages or that kind of thing. And so there are some pros and cons, and depending on what type of entity is formed may change up sort of how it works and how much formality you have to maintain in order to kind of create that corporation. And I would agree with Ms. Davis that I don't believe that HOAs or any of these associations are perceived to be that they are categorized officially as an agent of the municipality. I think in some respects, in what happens in practice is that these HOAs, that the municipality is actually sort of, is delegating some of their authority to the HOA, but it's not as an agent and what's the opposite? The primary and agent, principal and agent relationship. And then and I think because of that, because there isn't that relationship established as that principal and agent, that's probably why I think that the municipality is not responsible for in enforcing those the covenants, what conditions and restrictions, the CCRs. I think I answered all of Member Cole's questions, did I? Or responded to them at least?
I think
I don't know that
so.
I answered them, but I responded.
I think so. I think so. And as long as we're on that topic, it was also mentioned, and I'll take a point of liberty here, that there are three types, the nonprofit, the for-profit, and the cooperative. Could we get a brief clarification on what the difference between those three is?
Yeah, so well, of course, a for-profit association allows so that these a corporation, right? So they could potentially make money and they some kind of profit, and then and I think it goes to the taxation status. So their for-profit corporations are taxed differently than nonprofit corporations. And that, I think under, and I apologize, I'm not a tax expert, but you have like the 501c3, you have a 501c4, you have, I think there's like a 501c6 or something. So there's all these different non-profit, and it changes up their taxation. So that I think is the primary difference. The cooperative association, I think is, it's just in terms of, and I'm not as familiar with co-ops as well, but it's it's where the members, I think it's sort of like the co-op actually owns the building, like they tend to be in a building, that kind of a thing. And so it's unfortunately, I'm sorry, I don't have my brain just went out my head of trying to respond to that one, but it's just a slightly different structure. And
Absolutely.
yeah.
No worries. Thank you for that. Ms. Davis, did you have anything to add to that?
Yeah, I would just add that the housing cooperatives generally in Minnesota are going to be governed under Chapter 308 in Minnesota statute. There are a couple other statutes that touch on it, but that would be the main chapter that governs those housing cooperatives, and they're generally treated slightly different. And as Ms. Morton was alluding to, they kind of have a different, they operate a little bit differently than a nonprofit or for-profit CIC and HOA.
Okay. Thank you for that. All right, with that, I'm going to move on to Vice Chair Lucero was next on the list.
Well, thank you, Madam Chair, and this is a great discussion. I think my questions were already answered in the conversation that just ensued, but it was along the lines of, I just wanted to get clarity that the nonprofit entity type that HOAs are predominantly formed under is not, there isn't a specific entity type for HOAs. Instead, it's the entity type of a nonprofit, and then the statutes that govern the nonprofits agnostically is what's governing the HOAs. But I think that was where I was leading, but I think that was answered. So I would just submit it for then the body's consideration. Where I'm going anyway I have interest in carving out and dedicating a chapter in statute to govern HOA specifically, not just have them fall under the umbrella of nonprofits. So that's kind of where I'm going as I'm listening to this conversation, so we can have very specific requirements of the board and their powers, etc., by having, again, carved out a specific statute for that entity type alone. So thank you, Madam Chair. But again, I think my question's already answered.
And just a point of clarification for Ms. Morton, I think you had mentioned it, that there was some states that do have sort of like a certification process or a licensing process. If I understood the slides correctly, Minnesota does not have that. Is that sort of in line with what we're talking about here?
Madam Chair and Senator Lucero, so in terms of the reporting requirements and having to comply with both as a nonprofit as well as the association, I'll answer that with an example. So in Florida, they are required, I believe, to file as a nonprofit corporation. So and Florida has a requirement that the board has to file some kind of registration because they're a homeowners board, right? They're an association board. But then also any nonprofit corporation has to file a certificate or a registration as well. So what happens in practice then is in Florida, the board has to file 2 of those those requirements. And it that second one about that being the nonprofit, that applies to all nonprofits. They all have to file that one. And then I'm sorry, the certificate, let me get back to my slides really fast on that one. The filing, correct. I did not find anything that was specific in Minnesota law that required an association board to file a certificate or a registration paperwork as a board. I didn't, unfortunately, due to lack of time, I didn't go and try to figure out all the states that if they have to do it as a nonprofit, as their corporate entity. Unfortunately, I didn't have time to draw those dots, but I was familiar enough with, I'd seen articles about Florida, so I was aware of Florida's.
Thank you for that. And I will tell you, just to frame that for folks, I know there has been some conversation about how we get a handle on how many associations we have, where they are, what that looks like. And that may be some of that ambiguity may be due to the fact that we do not currently have a licensing requirement of any kind for those. And I believe Vice Chair Lucero has been talking about and I think Senator Pa, if I'm not mistaken, have been having some conversation about that particular topic as well. And with that, unless there's anything else, Mr. Vice Chair. No? Okay, well then let's move on to the next one on the list. I have Mr. Hanson, or Member Hanson.
Thank you, Madam Chair. My question is for Ms. Davis. So just by way of introduction, I'm Joel Hanson with North Country Cooperative Foundation. So we work specifically with housing cooperatives and more specific manufactured housing cooperatives. And so I wanted to go back to your slide number 3, which referenced the application of statutes and the 3 chapters of CIC law in Minnesota. So 515, 515A, and 515B. As you probably are aware, the legislature passed the 308C cooperative housing statute last session, which now doesn't only deal with the incorporation of housing cooperatives, but also the governance of housing cooperatives with that statute. So I was just wondering if you could maybe touch base a little bit how that interplays with 515B and those 2 governing statutes.
Chair and members, I don't have anything prepared on that today, so I wouldn't be able to do that, but we could maybe save that for a future meeting if that was something people are interested in and how those 2 work together.
If it's all right with you, Member Hanson, can we put that one in the parking lot and we'll follow up with Ms. Davis and see if we can't get an answer to that question for the members? If that's works for you?
Absolutely, Madam Chair, and Ms. Davis's suggestion that we maybe have a meeting focusing on housing cooperatives and how they're governed in our state as a CIC or HOA would be much appreciated. And Madam Chair, if I may, and this might be a parking lot question as well, but Ms. Morton, do you have any information about how housing cooperatives generally are governed under CIC HOA statutes nationally?
Madam Chair and Member Hanson, I don't have a lot of detail. Unfortunately, I didn't, just for preparing time, I didn't spend a lot of time on them, but there are some state, there are few states. I don't want to try to put a ballpark on it. It's a smaller number, but that they have specific statutes for the cooperative association. And I believe they're, and I'm not sure. I need to double. I was going to say I need to double check. But there might be the uniform law commissioners may have created a uniform law specifically for them as well, but I would need to double check that one off the top of my head. The piece of paper that I have all of them written down on is escaping me at the moment. But there are a few, yeah, so there are a few states that they have specifically done statutes specific for the cooperative associations, and so that they're separate from like the HOAs and the condominium, the condominiums.
Thank you for that. I appreciate that. And we'll try to follow up, Member Hanson, and get some more clarification on those questions for you. I appreciate that. All right. If there's nothing next, we have Member Kimball was next on the list.
Thank you very much, Chair Banner. Ms. Morton, I was wondering, a lot of the testimony that we've heard as we've been part of this task force has been about lack of transparency about who is on the board of the HOA, lack of transparency about meeting minutes, clarity of elected membership and term limits, and also just clarity of sharing financials or maintenance plans. I'm wondering, how do other states speak to requirements of open and transparent operations of CICs, and what are some of the best practices?
All right. Ms. Morton, it looks like may have an answer there. Ms. Morton.
Thank you, Madam Chair. Thank you, Member Kimball. Yes, there are some states that have statutes about I think you said, in terms of setting the elections, and sharing of the financial documents. And I apologize, I don't remember. There was a third one. I'm sorry. Unfortunately, I didn't create maps on those. So I can certainly get back to, pull some of that and get back to you on that. I will say that one of the things that struck me as I was trying to go through some of the, as I was going through the statutes and trying to find, like what are similarities that I can kind of pull together, that where some of the states have, where they adopted older laws, right, where they've been on the books maybe since the 60s and the 70s, and they haven't really, maybe they haven't done the law commission, or where they've kind of left them kind of on their own, and they haven't been changed a whole lot. I was struck by that some of those, they're very kind of bare bones. There are a few of them where, and like, I couldn't find anything, because one of the categories I was trying to look for was like open meetings. And like if you have to have, like, are there requirements for proxies for voting that way? And there were a few of them where I was struck that there really wasn't any language about the meeting, any kind of meeting requirements. But there are some that definitely have gone in, and they talk about how they list the terms, the election term for the board member. Off the top of my head, I don't know. I'd have to go check to see if there are any kind of term limits, or if it's just that, they specify the term, but that you can be reelected as many times as as you want to run. But there are definitely provisions in the statutes about how, like, what, sharing of the financial documents with the members. And so I can certainly work on some of that and share that later and send that to the LCC staff, excuse me. And so that can be shared with all of you.
Yes. Thank you, Ms. Morton. I know that transparency has continued to be a hot topic as we've had conversations. And I think there's probably, if we're being honest, when we were just talking with Vice Chair Lucero about things like licensing requirements and so forth, one of the items you mentioned, for example, is just a list of who are the associations, who are the board members that belong to that association. Those will probably be addressed through something like a licensing or certification, which we don't currently have in Minnesota. So I think that might be part of the angst. But then Ms. Morton spoke to the other pieces of that, which are specifically around what are the requirements around financial document sharing, what are their open meeting policies and procedures around elections or proxy voting. I will say in full transparency that I did actually have a bill last year about specifically about open meetings and proxy voting as well. So just to be clear about that, and I suspect that will potentially either become part of a larger bill or we'll seek some clarification based on the outcomes of this work group to define those, and will likely be informed by the recommendations of this work group. So just wanted to be transparent about that.
And Madam
that
Chair,
is
if I
out there.
may, I'm
Yes,
sorry, I don't
and
mean to
Ms.
interrupt.
Morton.
I know that there are I remember saying that there are a handful of states that do have a requirement that maybe like the Secretary of State or some kind of agency has to create either an electronic record or a database of all the HOAs or all the associations. And Colorado is one of those. I don't want to use Colorado too much since that's where I live as an example. Don't want to show a bias. But I know that they have where their Department of Regulatory Agencies has an office that does they have a registration requirement, and that some of that is that they're creating a database. I believe they're creating a database so that they of at least so that they know who all the different associations. I don't know whether it's that database is publicly available, or how they share that, and whether or not you can see who all the officers are, the board directors are. But they are collecting that data, some of that data.
Right. And again, for full transparency, that is something that I know some of the legislative members have been talking about, that database idea. Ms. Davis, it looks like you have some additional input.
Yeah, I was just going to refer back to, for I believe it was Ms. Kimball who was asking about it, but just in the Minnesota statutes, you'd be looking at 515B.3104 for meetings and notice for meetings, section 109 for the quorums, and then 110 for voting and the proxies. And the proxy, that law in particular was updated in 2010 related to the proxies. So just if you wanted to look at current law right now.
All right, very good. I will tell you that some of that may be driven, Ms. Davis, by some constituent letters about those specific topics too. So appreciate that insight. All right, and then I think if that has been answered, I think we have member Murray, was it, that had their hand up next?
Yes, Madam Chair.
Yes.
Excuse me. Ms. Morton, I was hoping that you could speak if any of the states have best practices written into statute or another agency to help support the logistics behind that transparency and maybe going beyond that to for the member training to provide kind of the logistics that to support good governance and governing with emotional intelligence to avoid fights. I know we at my condominium had repeated fights over turning off light switches in the laundry rooms. And we had some older people with bad memory problems and younger people with ADHD. And the solution there was replace them with motion sensors, and like then the fight is avoided. So and that's fundamentally, guess, a thing surrounding disability where you can have a fight around it, or you can recognize that both culturally and physically, society disables us when the expectations of society don't align with our um abilities, and help train people and provide resources to avoid those fights.
Very good. I'm not sure, Member Murray, if I heard a question in there, or was that more of a comment?
Specifically, training for emotional intelligence and like the logistics. Um, I love the idea, and I had spoken with the Secretary of State to get more information for you about like they have the documents that we could have, but they are scanned, but they aren't OCR. So like that's a system that supports you knowing who the um people are, like what associations we have in the state of Minnesota. We have the data, it's there, it's not in a usable format that you as a legislature can ask for. So like I'm asking, there are a lot of these little systems like training for um the boards, like good systems for the state. And I was asking what states have what that helps support us working together. Like automated registration would be great. So like you don't have to have legal liability for if somebody forgets some year. My association has forgotten to press the button and renew because it's not automatic. So like if you can describe what states have what to support people in like both training and like automation for state like compliance, and if there's any other innovations that help people just get along and make HOAs easier and better to live, like I would love to know.
Yep. And I thank you, Member Murray. So I just want to be clear about two things. I will also make a shameless plug here that we do have a future meeting topic specifically to talk about affordability as well as civil rights and disabilities and things like that specifically. So I just want to make sure that all members are aware that that is a future topic coming forward. So we will probably have more discussion there. Not that we want to stifle it today, but just being clear that that is another item coming forward. And then, of course, if you know folks who want to testify on that topic, please reach out to staff. We would be delighted to hear that. And then if I recall correctly, from the conversation that we had with Ms. Borton, that there are some states who have specific training or educational requirements for board members. And if I am not mistaken, Minnesota was not included among them. Is that, I seem to see some nodding of agreement. And that may be something that I think has come up as a theme before that we may want to explore as a state, adding into that. And if, let me see, I actually wrote it down. The folks who have education requirements was New Jersey, Utah, and Florida were the three states that do have some. So that may be some states where we might want to look for some more information around that specific item. And that could, I think it included things like financial literacy, record keeping, meeting laws, transparency, meeting notification requirements, and such. which may also be a valuable for us here in Minnesota, because it sounds like that is not always happening on a consistent basis. And again, with smaller associations, some self-managed, some larger, it might be helpful for us to set some guidelines around that to make sure there's more transparency and clear communication with homeowners and boards.
Madam
Any-
Chair. Oh, sorry.
yes,
I was going to say, if
Ms.
you want me to
Morton.
respond, sorry.
Yes, Ms. Morton.
Yeah, so unfortunately I didn't see, there's not a lot of detail in the state statutes for those few handful of states that have this kind of educational requirement or requiring to, collect some to provide resources. They didn't go into a lot of specifics. The Florida legislation or statutes that I found, that was the most specific, and they didn't mention anything specific to sort of like emotional intelligence but I imagine that some of it at a minimum, right, that they may have stuff about, there might be some stuff about like conflict resolution and maybe some negotiation, that kind of stuff. Unfortunately, like I said, I didn't see anything specific to emotional intelligence. And I think I want to say that the New Jersey and the Utah, those two states were more about that they would make resources available, but they didn't define what that would be. So I'm afraid I haven't seen anything.
Okay. Well, and it may be an area ripe for improvement. Considering there are only 3 examples of that nationally, and certainly it does feel like we have heard time and time again that might be a consideration to help as associations expand across the nation, to give a little bit more guardrails and really help with that transparency and communication piece. All right, thank you, Ms. Morton. Ms. Davis, did you have anything to add on this topic, or should we move on to the next?
Chairman, no, I don't have anything to add on that piece. We don't seem to have that here in Minnesota, so it's a area to look at.
Okay, thank you, Member Murray. And with that, we will move on to Representative Meckland, who had a question.
Thank you, Madam Chair. My question would be, I think it was Ms. Martin acknowledged that, there's different states that have different statutes governing. Can somebody put together, like, perhaps what is the state, or which states have the most strict governance over HOA CICs? To use that as a baseline for one side versus, it sounds like we're pretty, Minnesota doesn't have a lot of guidance of what HOA CICs or requirements are. Both to, as was discussed, the transparency meeting minutes, what was the guidelines or the requirements in the previous HOA before the new board was seated versus if they abruptly change something. I mean, is there any, I guess what I'm looking for is do we have any examples of what other states have done to help rein some of that and create more uniformity and perhaps protections for the individual homeowners?
Ms. Davis, it looks like you may have something.
Chair and members, I don't know if, I think there's more a question for Ms. Morton, but I don't know if NCSL currently has like a database that shows what laws apply to HOAs and CICs. Doing a 50-state comparison would take some time, and sort of figuring out whether or not they're comprehensive or not is a little bit subjective. But we could, I think NCSL probably would be a good resource in terms of compiling what laws are available in other areas related to the governance of CICs and HOAs.
Question on that, as a clarifier. So as I was following along with Ms. Morton and your presentations, what I heard is that we actually do have a few areas in which we actually have complied or tried to find some uniformity. And I'm sorry, I'm going to butcher the titles of each of them. Was trying to go back through my notes to look at what they were exactly. But the three regulations that we had, and I think we had adopted a number of those. And I think the point of those was to try and get that uniformity, or to some degree. And I think, I'm trying to remember if it was you, Ms. Davis, or Ms. Morton, who mentioned I think it was you, Ms. Davis, that mentioned the Minnesota Uniform Condominium Act of 1977, the Common Interest Community Act of 1982, which was revised most recently in 2021, and has been updated 3 times, as well as the ULC. I'm not sure if that's a third one or if I just mixed that up in my notes.
Okay, I don't know.
Yeah, I
Would
think
you
we,
like me? I think you
Ms. Morton,
combined some
go
of
ahead.
our note.
yep, I think I was just gonna say, I think we talked about some of those, but different ones. So in Minnesota, the earlier statutes do have like kind of like the word uniform in them and things like that. 515B is a uniform law. It has state-specific provisions, but the main governing chapter in Minnesota law for CICs and HOAs is a uniform law. And it, and because it's uniform law, it's fairly comprehensive in what it covers. And that was kind of one of those last slides I did where I walked through the different things that are in that chapter.
Okay,
And Madam Chair, if you like,
Ms. Morton.
thank you, sorry. So the Uniform Condominium Act of 1977 was from the Uniform Law Commission, and that has not been revised by them. But the Uniform Common Interest Ownership Act, which was also drafted by the ULC, that has been revised 4 times total since it was first promulgated. And so like Ms. Davis said, yes, you guys have enacted, and I apologize, I don't know. I think you just said that it was which I think Ms. Davis specified which version it was. I apologize, I don't remember. But in terms of circling back to Representative Mecklen's question, and just as Ms. Davis said, unfortunately, sort of trying to rank the states in terms of which one is more strict and maybe which one is more lenient and which one has best, all of that, which is the strongest, which is the weakest. That is, unfortunately, is pretty subjective. And I'm not, when you look at the grand scheme of things, unfortunately, that's kind of really a difficult question to answer. But I certainly, yes, I have the list of all the state statutes. And I can certainly share that, and and so that at least we're I can work with Ms. Davis, and we can try to pull together, some comparison, so you can see the text of how they, in a particular area. I would say that it, in terms of to be effective, it probably would work best if you could, if there's a specific, like, are you looking for like the election of board members, something like that? Because some of these statutes, they're very, very long. Some of them are not. And so that could be a very large project that may not that would take a lot of time to pull together. May not make your deadline for when you need to do your report. But certainly if there's like specific, something, where we can narrow it down, that would help me, that then I can, I can pull some of that, and so that you can actually just see the comparison of what the states have done on a particular issue.
Here's a question. I think we've identified a few different sort of more uniform areas where states have adopted various things from state to state. But I'm curious, and I'm sure somebody has it somewhere. I don't know if you do, Ms. Martin or Ms. Davis, but I'm assuming that there is somewhere some sort of a comparison of some of these items we've discussed that sort of compares how they treat certain issues or elements, and sort of what the similarities versus the differences are. Do we know if that sort of exists somewhere out in the ethos, or maybe it does, we just don't know where it is.
Madam Chair, I would say there are some resources, but and I am blanking on their acronym. CAI was a Community Association Institute. Sorry, and I know that they spoke, I think at your second meeting.
Yep.
I know that they have some comparison, but well, I should say, they have some maps. Like big on maps, but on their site, they didn't go into a whole lot of detail. It just was, like they list the state, like who has it and who doesn't. But certainly, like I said, because that's absolutely, as legislators, right, and legislative staff, that is a service that we provide. So if, like I said, if there's, like if I could, it would help me to better help if there's specific things, like, okay, yes, we want to know, like give us the statutes for the states, that how they elect their board members, like that's something I can pull together a chart for you. And what I would do is give you the language so that you can see it. But as an I don't know that I can rate the states. That's not
okay.
something that I can do,
No.
but I can certainly give you that, so that then you can go through it and you can see, okay, and kind of say, okay, yeah, 10 states do it this way, 12 states do it like that. That's something that I can do.
Yeah,
I just can't say which one's the best and which one's the worst.
Chair
Ms.
members.
Davis.
Oh, chair members, I was just gonna say, yeah, if there's like a specific question, like you want to know if other states have a longer meeting notice requirement or something like that. Like if you have a specific question, that would be helpful in terms of having us do that kind of research. So if it's something like that, like we can look at those very specific issues, like what does everyone have a quorum law similar to Minnesota, or does everyone even have a quorum law? Things like that.
It feels like you mentioned, Ms. Davis, that there were sort of three phases of the law, if you will. And that those were loosely, I mean, we customized them a little bit to fit Minnesota, but loosely they were an attempt to try and somewhat conform across states. And I was asking about the comparison between those phases. And it just so happens we do have Member Howard, who I think represents the Bar Association. And I'm curious, Ms. Howard, do you know if such a comparison exists between those phases that sort of compare sort of the similarities and differences of those particular legal elements?
Madam Chair, are you talking about the comparing our state statutes, or I'm not clear on the question.
We were talking about the fact that there were sort of the three phases, and we had the uniform, and I'm trying to make sure I use the right terminology here. The sorry, the Uniform Condominium Act, the Common Interest Act, the Unified, okay, I can't read my notes, Common Interest Law. Okay, those are actually probably the same thing. But between those, is there any sort of comparison of how the various pieces or core functionality of those two or those provisions line up in terms of what's the same, similar, different in terms of how they treat the law?
Sure. So 515, which was the first condominium act, is very, very bare bones. If you go and look at what Wisconsin has, they're still kind of where 515 is. So very bare bones as far as what it even attempts to address. And that applies only to condominiums. And then the 515A, which was the Uniform Condominium Act, again, only applies to condominiums, but much more comprehensive. And then 515B now extends to not just condominiums, but also townhomes, cooperatives, planned communities, other than, at least in Minnesota, other than the detached single-family homes, but all of your attached kind of property is governed under 515B. It's very similar to 515A, a little bit more comprehensive, but again, extends the application to other types of associations beyond just condominiums. And all of 515A condominiums are currently governed under 515B. So 515A really doesn't apply at all anymore. 515 condominiums are mostly governed under 515B, but there's some sections that don't apply because like those documents just don't account for things that are now in the statute because again, that statute was so bare bones. So I hope that helps.
Okay. All right. Thank you for that. All right. I think it does a little bit. With that, I do not see any other hands raised at this time for members. So we could move on in the to the next phase of our agenda, if there are no other questions, and let our esteemed speakers go. I do want to thank both Ms. Morton and Ms. Davis for being here today, for walking us through some of that, and of course, answering some tough-hitting questions, including a couple in the parking lot that we'll have to circle back around. But I really appreciate that. I will tell you all that we had originally intended to have a subject matter expert that dealt more with the application of these specific governance issues in real life, that had been planned for today that unfortunately could not make it. So my apologies that we were not able to have sort of that lived experience lens in our conversation today. But hopefully they can come back and speak more to this in a future meeting as we proceed. But my apologies that that didn't work out with them for today. All right, then we will move on to the next part of our agenda. And we do not have a great deal of time left, but I just wanted to kind of go into the next piece of what that looks like. So we've talked a little bit about the mission of the work group to sort of study a number of issues outlined in the statute. But ultimately, in the end, the mission of this work group is to create a series of recommendations that could inform potential future legislation and what that might look like. I actually have started compiling out of the notes some of what I have been hearing, working with staff on that issue, and we're going to continue to do that just to have a starting point for discussion. But I wanted to mention here that I think one of the things that I'd like folks to be thinking about as we're having these conversations is to think about some sort of the guiding principles behind that. And if I can, I have a, see, I think I have it open on my desktop here. Let me see if I can share that. Let's see. Hold
You
on.
can also share if you're having trouble.
Trying to figure out how to share the recommendation page from the shared drive here. And I think I just need to go to share, right? And let's go to here. And what do I want to share? I want to share this one. And I'm not sure if folks can see it.
We can see it.
Okay, very good. So, in terms of guiding principles, I think as we consider our recommendations, I would say that there's been some sort of themes that have been emerging through our discussion. And I think they're actually really good, solid principles that we try to think about whenever we're putting together legislation, in general. And so I've listed them here on the side of the screen, talking about sort of that reasonableness standard, fairness, transparency, clear communication channels, stating things in plain language, as well as legal parity seem to be themes that have emerged in terms of guiding principles from our previous discussions. And I think it's good to sort of keep those in mind as we look through that lens of our recommendations, so that our recommendations really do kind of capture these principles and look at them. And I think we also want to think about, as we're sort of moving towards starting to talk about recommendations, some key questions. So when we talk about these standards or recommendations, we may want to be thinking about who's responsible for this, who's accountable for it, who should be consulted or informed in each of these recommendations. And I think that's, for those of us who live in more of a project management world, you might be familiar with this. Yes, it is a racy diagram, but it does belabor some of the same questions that we may want to consider as we're thinking about recommendations. What is our recommendation? Who is going to be implementing it? Who's going to be accountable for it? And how that impacts those who need to be consulted or informed. So just throwing that out there. We did, through the presentations we've already heard, I started to try to categorize them and start to put some sort of pen to paper. We'll obviously need to flesh out greater detail on these, but I did start them so that we have them. And I thought what I would do is sort of open the floor to say, in today's conversation, we were talking about governance and governing documents. And I wonder if there are any specific recommendations that folks have that they think might be useful for us when we talk about governance to consider as a recommendation. I know that one of them that came up multiple times was this idea of licensing. And so I've kind of added that one in already. I think if we were honest, I also think I heard one around sort of requirements around I just mucked that up. Around training and education and what that might look like. And of course, these need more fleshing out, but I think that became a theme from today's conversation. And I see Member Kimball, you had a thought.
First, Chair Boehner, this is excellent, and I'm so excited to see it laid out in this way. This is so great. My thought was to include something about conflict of interest. I thought the map showing how many states have a conflict of interest policy and then how many states do not was something really compelling from today. And it makes me think in particular about the story that was in the news recently about roof replacement.
Yes. And I think what we have heard that theme emerge many times. And I think that is definitely a concern, is having some sort of conflict of interest in our statute to really govern that and give some guardrails around it. What is and what isn't a conflict of interest, what that looks like, and of course, how we address those concerns. Sorry, I want to close that down. Member Howard.
Thank you, Madam Chair. I actually wanted to respond to that because 317A does have provisions for conflict of interest. So it's in the nonprofit corporation statute, just does not happen to be in 515B.
Okay.
So there are provisions already in place for that.
Thank
for
you
board
for that.
members. Mm-hmm.
It might be interesting, and that's for board members, but that doesn't sound like it may apply to some of the other outlying issues, such as the one that was outlined by the Minnesota Reformer. And I think it sounds like, and maybe you can clarify, does 317A, the nonprofit, does that, I assume that only applies to nonprofits, but would not cover other types of common community association types. Is that a fair assumption?
Thank you, Madam Chair. Yes, so the 317A applies to probably 95% of all community associations in Minnesota. The other 5%, well, I take that back. I've seen a handful that are accidentally formed as for-profit. I don't think that was the intention. I think that was a mistake. Otherwise, the rest would be the cooperatives, and those would be under 308A currently. New ones will likely be formed under 308C when that goes into effect.
Okay.
Which I know we were putting in the parking lot to talk about 308C.
Yeah. Okay. All right. Member Cole.
Thank you, Madam Chair. One thing I would love to see addressed and more fully fleshed out is around the bylaws. There currently is no real requirement for the content of the bylaws or enforcing the bylaws. For example, when I asked our management company where their authority came from, they said that I've been told a couple of times it comes from the bylaws, but yet they wrote the bylaws and there is no real requirement for anything for the content or for the implementation of the bylaws. Plus the bylaws can be changed on a whim and with no real direction for what they are and what happens with them when they're not followed. And so I would love to see something a little more comprehensive around if we're going to use bylaws as a governing document or a quasi-governing document, some more substance to them and what that is and what that contains.
So I sort of heard out of that some sort of the content, greater clarity around the contents, the enforcement, change standards for the bylaws. That
Right.
would seem to be the main themes.
Right.
Okay.
Yes.
Okay. All right. Member Zavadsky. Did I get that right?
You did. Thank you. I was just coming off of mute. As we speak to the effect of conflict of interest, I'd be interested to better understand what conflict of interest you're discussing. You mentioned the Reformer article, which of course we read prior to this meeting. I think it's important to note from an industry perspective, though, generally accepted practice as far as insurance claim proceeds go. People within this industry, as you work through an insurance proceeds contract, a general contractor typically is not going, when you have an insurance loss, you're generally not going to bid it out. And there's a reason for that. The contractor will provide what's called a insurance proceeds contract. So they are going to guarantee that they're going to do it for the price of the insurance proceeds. So then it typically becomes about a relationship that the board of directors has had with maybe a prior contractor that has previously done the work, or one that they know will do a good job with the insurance proceeds that they're receiving. The reason why you don't bid it out is because you're not going to get alternate bids. Every contractor is going to know that there's an insurance claim, and they are going to provide, again, what's called an insurance proceeds contract, where they are guaranteeing to reconstruct the premise per the insurance proceeds. So whatever the insurance company awards, that's the amount that they're going to use to reconstruct the project. So the amount isn't going to change if you bid it out. So then it does become about relationships and become about who has done work at the property, or about who the board of directors knows is going to have a reliable warranty and does reliable work, so that those insurance proceeds, of course, aren't wasted.
And I do think there's something to be said for having those relationships, but I also want to be clear that I think from a public perception, I think there is, when there's those relationships, it's also possible that we are awarding lucrative contracts and for large sums of money to folks that may have an interest or knowledge of someone on the board. And I think from a overall conflict of interest statement that we need to be thoughtful about that and what that looks like. And I can see where the general public might have real concerns with that. And by doing so, we also need to acknowledge that there is the potential for abuse. And it sounds like there's some suggestion based on the article, and I don't know that that's been proven out yet, but there is a suggestion that there may be some inappropriate things going on there. And so I again, that needs to be litigated in other forums. So we don't want to, give anyone a black eye here. We don't want to assume improper intent of any kind, but certainly there is a certain perception with that. So I think we do want to be thoughtful about what that might look like. And I would be interested to see what the conflict of interest guidelines are that other states have employed, and how those might be the same, similar, or different from what we have in existing law in Minnesota. So, but thank you. I appreciate that clarification. All right, member Borden.
Hi. Thank you, Chair. I was going to be asking a question more about the procedures or process for our working group, just in general, based on the list that you've been gathering through all of our conversations. And I think this is a very substantial list, and I love that we're starting all of this. My question is wondering, as we move forward and we're working on the recommendation, what percentage of the group is to approve the list? Is what type of discussion is going to be taking place? And before that final report is submitted, and will there be an opportunity for possibly a minority report that will be drafted, just as we start to dive into the actual work of what we're going to be doing in this group?
I would be upfront. I don't know that I like the concept of a minority report. I'm not sure that that feels very conducive to working as a group. I will say that the idea here is to start putting together a list. And again, right now, this is a draft list. This is not by any means all of it. It is not everything. It is not everything that might be included or not included. I just want to be very clear about that. The point of starting to put this list together was really to start to sort of have something that we could work from and have discussion on, not necessarily that it will be the final list. So I just want to be very crystal clear about that. It's just more helpful for groups when they're having discussion to have something to go off of as a springboard. So that is the intent of this list. It is not by any stretch what would be in a final report by any means. So I just want to be crystal clear about that. This is just collecting ideas for right now for discussion. That is what we are doing. And some of these may be more fleshed out, some may be less. We can certainly decide which we want to include in our report and so forth. But it is really to help facilitate discussion. Does that answer the question?
Yes. Okay. Thank you.
All right. Member Daly.
Thank you, Madam Chair. I just wanted to mention two things that I hope the group will think about. One being sort of homeowners' access to the governing documents. I have definitely worked with folks who can't figure out how to get their hands on the documents. And I think that's a big deal. I know many of them are recorded, but that's not a very easy way for homeowners to access them. Oftentimes they are placed on like a website, but some of my senior clients have a lot of difficulty accessing that. So I think it's important for us to think about a way to make sure that homeowners can always have access to the documents at no cost to them. That's one thing. And the other thing I wanted to mention was that a lot of these, especially the bigger associations, are managed by property management companies. And I don't think there's any provisions of the CIC statute or any law, I don't think, that sort of binds those property management companies. And I think the reality is that sometimes a lot of things happen just because that's how the property management company does it. And it's not necessarily a decision of the board, or that the property management company sort of understands the issues or has a lot more experience than the board does. So I just sort of would like to think about the concept of having some of portions of the statute actually be binding on the management companies and not just the board, the association and the board. That's my comment.
So, and I'm trying to, so binding to the property management versus just the board?
Yeah, I mean, in terms of these conflict of interest laws or these, I mean, I'm assuming that most statutes out there that do address that, or that would be sort of as to the board, I would think, because that's the governing entity, but it would not be as to the management company. I don't think. I mean, I'm not an expert on what the current statutes say on that subject, so I don't know, but just to keep in mind that very often who actually runs these associations in practicality is the management company. I mean, they maybe don't make the major decisions, but the day-to-day decisions that do very much impact homeowners are taken by the management company often, and not the board, not the association.
All right. Got it. Any other things particularly specific to our topic today on governance that we think might be potential recommendations? And again, these are suggestions. These are not law by any stretch. Representative Meckland?
Thank you, Chair Bonner. Since you guys brought up this recent case that involves an insurance claim, as somebody who's done quite a bit of storm damage in my career and tried to review through the documents on this particular scenario, apparently this insurance policy changed at some point. A lot of the homeowners, tenants, what have you, but mostly homeowners, were not aware of the different policy coverages. And I think there needs to be something in there, and or if a board changes due to elections and suddenly they adopt new rules or requirements of each tenant and or homeowner, like they often, I hear that they sometimes they're kind of petty, to be quite honest, and like where they should have boundaries perhaps going forward, like how little they can get into it, whether it's you can't plant certain flowers in your front flower bed. I actually heard about that from somebody who doesn't live terribly far away. I mean, there's just like a lot of these different types of things. And then when insurance policies change, but based on whatever the deductible may be, or the requirements that was previously established as to what the responsibility of the homeowner would be beyond what insurance pays. And that's not very well delineated to the homeowner upon a policy change. And there should be, I would think, some kind of better requirement that this information has to be well explained prior to the acceptance of this, but especially if it's done by a property management company. And because the HOA or the CIC, kind of offshore the authority to the property management company, and then they have arrangements they may have, or preferred contractors, what have you. So, I mean, this crosses into many different lines of law and statute, which is what's so unique about this and the governing bodies. But in talking to not only the case that's been referenced, but there's another one that's actually in my district. And it seems that the homeowners in the one that's in my district, they're basically forced into an awfully expensive per unit demand with no guarantee that what will become of all this money. And there doesn't seem to be any guardrails to protect the interest of the homeowners versus you have an out-of-state entity collecting all this money over the course of 3 years, but there's no guarantee like where this money goes, if it does get done, great, but if not, what happens? And there's just a lot of very interesting dynamics to this whole very complex work group. But somewhere in all what I just said, Chair Bonner, there's a lot that needs to be addressed in this, and I think more so in maybe on both sides, but there seems to be a lot of loose or very ambiguous protections or non-existent protections for that of the homeowner, particularly if future elected bodies of the association either change things, drop things, adopt new rules or new regulations, and the homeowners aren't aware, or suddenly, based on changes made, they are subject to this very significant assessment, and they're kind of blindsided by it without any kind of forewarning, if you will.
Okay. Okay. And hopefully I'm capturing what you're thinking, Representative Mecklen. If I've not, feel free to pop something in the chat if I haven't stated it correctly. I'm open to being wrong, by all means, or if I missed something, by all means, feel free as well. Member Murray.
Chair, I would just like to recommend that we help associations with logistics. And that's if we can make the bylaws public every time they're changed at the Secretary of State, that is one conflict resolved there. And if they're all using shared documents like you're doing right now, and they're shared with the association by default, I'm ambivalent to whatever software package that is, as long as it is accessible and works for people. But helping associations get sorted out so how they do things is easy helps them do the things.
Okay. Okay. All right. Yes. We'd probably have to consult the Secretary of State on but some of that, but I understand what you're saying, and I think it speaks back to a point made earlier about sort of how we clearly communicate changes in the bylaws or assessment. It gets back to that communication piece, and how are we doing that? How are we applying reasonable standards? All of that, and I think we're hearing sort of themes of the same thing, but kind of again, this might need some cleanup, but we'll go through and do that later. We're doing that on the fly right now. So, any other members with things specific to governance? Member Howard.
Thank you, Madam Chair. I hear a lot of what people are talking about, and I just want to point out that most of these things are already existing in current statutes. I think the biggest issue from my perspective is education. Homeowners need to be educated when they go into an association as to what it means, how things work. Board members need to be educated. The real estate agents that are helping people buy into associations need to be educated. I think it's really an education issue. And to the point of Representative Mecklen talking about things being communicated, my experience is associations over communicate and homeowners ignore it. They don't pay attention. And we can't make them read the things that we're sending out, but the information about insurance policies, every time the policies change, which is once a year typically, that information is routinely sent out to the owners so that they know what kind of coverage they need to get to protect themselves, and owners don't pay attention. So I don't know that we need to change the laws in a lot of these areas. I think it's an education piece from my perspective.
Okay. All right. Good to know. All right, Member Cole.
I thank you, Madam Chair. I don't agree necessarily that it's an education issue, but it's an enforcement issue. We want to make sure that the homeowners are informed in some way to validate that the homeowners are informed. But when they're not, or when there's information missing, or somebody decides to inadvertently and select it, or not even inadvertently, when they selectively enforce the bylaws, then what do we do about it? Where do we go with it as a homeowner? So I agree, education needs to be part of it so that homeowners are informed, but the education about the association also needs to start before the homeowner even gets into the home, so that there is an informed choice and the education is ongoing. But the other side of that is around enforcement. So what if we have all these laws and rules and things, and that there is nowhere to go with it and nobody willing to help enforce them? That is a huge issue for us as homeowners when the association gets to make up things as they go along, and we're just subject to their whims and at their mercies. So that needs to be part of that as well.
Well, and I want to be clear, in terms of assuming positive intent, I'm going to assume that they're not just creating things as they go along. Hopefully they do have some sort of process or procedure, but what may be clear and what may not be happening is that those standards are not being transparent. We're not clearly communicating how those decisions are made, who has input into those decisions, why they're being there. It seems like there's a lot of that piece missing, is kind of what I'm hearing, if I'm being fair to folks. But I could be misinterpreting, but certainly that kind of feels like where we're at, if I'm being upfront. Member Moritz, if I'm saying that right?
It's Maratz, but close.
Maratz.
Maratz. Yeah, and I had to jump out. I got a call and I had to jump out for a minute. We're just still in like the governance section, which has to do with the boards. Like we're still going to make recommendations about enforcement in a separate chunk, right?
We can talk about it here right now. We did talk about enforcement of bylaws. We did have some conversation about enforcement here too. These certainly can come up at any time. We're just speaking to it in terms of this topic for today, but certainly there may be other things that don't fit neatly into a bucket, that certainly we can look for what those gaps are as we go through. And of course, if you have suggestions, feel free to bring them forward. We're willing to throw them in at any time.
Great. Yeah, I think my suggestion, the thing that we would like to see as a recommendation, is the creation of an ombudsman position. So we want there to be that person that homeowners can call and get help.
Yep. And I do think we have not talked yet about sort of dispute resolution, which is a future meeting topic.
Right.
But I do think there is some conversation to be had around that. And I thought I had already added one for that. But
yeah, I was wondering if this was available as a link so that we could scroll back. But I'm happy to.
Have it currently as a link.
That's great.
I'll have to talk to staff about if there's a shared place where everyone can access. I think mostly it's a security access issue.
Yeah, that's fine. I just wanted to make sure that.
But
yeah.
What I would recommend, though, is that whatever comes of this, we can certainly send out a copy of these for the members so you can see what we've recorded, and we can sort of noodle on if there's changes, amendments, wording, whatever, we can certainly noodle on that. Because I do think you do need to be able to have access to this list. Just to kind of look at it and have folks, kind of, again, think it through. So I appreciate you saying that, and I think that in the name of transparency, that is a good idea.
Okay.
We'll just have to work with staff to figure out what that will look like.
Great. Thank you, Chair.
Yep, absolutely. Member Green.
Thank you, Madam Chair. On your Excel spreadsheet on a previous screen, I think I saw licensing on there, and I just wanted to be clear of licensing. Was that of property managers?
I don't think we had clarified that point. We did talk about licensing, and I think that was originally referring to the associations themselves.
Okay.
But certainly that could also apply to property managers as well.
Yes, and I think that would be a good discussion. I think that's something that I see frequently, as maybe where there's a huge disconnect between associations and the property managers and members, is that there's an implied relationship with the property manager. The buildings believe, or the members believe, that the property managers always looking out for their best interest. And is there that requirement or responsibility, those fiduciary duties, or is there not? And is that being disclosed? And is that being, are the boards being reminded of that at times of, decision making, like choosing a contractor? And I know that we've talked about issues with conflict of interest, and Member Daly's comments, are very, they resonate with what I'm hearing in the marketplace. That issue of not just a conflict of interest on board with board members, but self-dealing is a topic that I think is worthy of further investigation. Thank you.
Yes, and I think when you're talking about self-dealing, I think we're getting back to that concept of that conflict of interest and what that looks like, and how that plays out as well. We've heard that theme quite a bit. So I think that is probably likely to make our list of recommendations. And certainly, I will try to dig deeper and get some more information from Ms. Morton on what the other states have in terms of that conflict of interest that Minnesota does not currently have, but sort of what are some of the high level things that they do have included in that? Is there a template or any specific modifications from other states that we could look to look at that, and how that applies to boards, property management companies, associations, and the whole kit and caboodle. So, but I think we're hearing that a lot. Yes. All right. Thank you for that. We are at 12 o'clock. I'm going to try to clean this up from what we talked about today, and make sure I didn't duplicate anything. But I will talk to staff about how we might get access to this, so that folks can see it, and in a more nuanced way, or if we just want to send out copies of what we have to the members so they can noodle on what's there and changes or recommendations, add notes, what have you, as we go along. But it is my intent that going forward, we will have a segment of our meetings that will be designated to have conversations about recommendations and starting to get something out there. Now, we will very likely need working sessions further down the road to walk through these recommendations in greater detail and iron out which ones should perhaps stay, which might be duplicative, if there's any gaps, what may or may not be necessary as recommendations from this body. So I just want to be sure that we are aware of that. But I would like us to start putting pen to paper in some more of these ideas so we have those starting points for our discussion as we get towards the end, when we actually have to put together a report of what those recommendations may be. All right, with that, I want to be respectful of folks' time and get you all out of here. Thank you all for being here today. And with that, with no further discussion, I am going to call to a close and adjourn the meeting of this work group on common interest communities and HOAs for November 15th, 2024. Thank you all, and we'll see you at the next meeting. And oh, I'm so sorry. The staff is going to get me because I did not mention it. Get you. The next meeting date is, and maybe staff has it already up and it's faster.
Tuesday, November 26th from 10 to 12 at the Capitol building.
There it is. All right. Tuesday, November 26th. And I knew that. I should have known that. Thank you, Ms. Pollock, for that contribution. We will see you on the 26th. And in the interim, we'll try to get answers on the parking lot items as well as getting a copy of this list out to folks and figuring out if there's a way to share it more thoroughly. All right. Thank you, everyone. Have a good day. Bye-bye.